Okay, there we go. Good morning, everyone. Happy to have you here today for our April Friday Forum. Our speaker today is Vivian Villers. I've had an opportunity to talk to Vivian a bit over the last few weeks, and I think you're really going to enjoy her presentation. She's fun to listen to, fun to talk to, and has a wealth of information to share with you. A little bit about Vivian. She's a seasoned financial advisor and compassionate speaker who specializes in, among other things, confronting the often overlooked, crucial planning areas for families with special needs children and conscientious legacy planning to avoid a mess, which we all would appreciate. Drawing from her experience and intimate understanding of these challenges, she crafts a compelling narrative that drives home the importance of preparation and foresight. Vivian's mission is clear: empower her audience to take control, minimize uncertainty, and ensure a secure, organized future for both their loved ones and their businesses. Her presentations are not just talks, they're a call to action to those who aim to leave a legacy of care and not complications. So please help me welcome Vivian Villers.
Thank you, Linda. I appreciate it. Before we get started, I just want to say I hope everyone will give me a little bit of grace. The spring season is here and the allergies are kicking up like crazy. So if I pop a throat lozenge periodically, I hope you will understand. That being the case, let's all dig in. This is my background for over 20. I've been a financial planner, independent, and own my own company for over 30 years. And I work with special needs families for over 25 years. I also work with women in business, entrepreneurs, and retirement and legacy planning. It's been my experience in the 20 plus years I've worked with parents and special needs families that most of them are on overwhelm. Your day-to-day activities of just taking care of your family, financial matters, going to the job, everything else, and then add in the needs of a child with a disability can be overwhelming. Or another issue that can come up is I have found that many parents don't even know where to start when they have a child with a disability, in starting with the financial matters affiliated with that. So it's been my plan to help parents learn how to take action. And that's my plan today, is that hopefully you'll come away with some concrete ideas. And if you'd like to have a discussion in more detail after this, please feel free to reach out to me. This is my story. I have a nephew, Stephen, who has autism, has severe autism, and is nonverbal. Several years ago, I was driving home from a conference in Michigan, and my brother called me. My sister-in-law had decided that morning to make a quick drive to the bank before Stephen came home from his daycare program. He was on the bus on the way home. She figured she had time. God and the universe had a different plan. She was killed coming home from the bank. And my brother was calling to tell me this. My brother was in Kentucky on business. I'm in Michigan. And when this happened, Stephen was literally 15 minutes away from coming home. And first responders were knocking on neighbors' doors asking, "Do you know this woman? Do you know how to get a hold of her family?" I want you to put yourself in those shoes and think that if a family member of yours got that call and you feel helpless and there's no plan in place, what would you do? That's what happened with my family, and that's when I made it my mission to make sure it, wherever possible, that parents will take action now and do something. The chaos and trauma that my family lived through that following week, plus what Stephen was subjected to, could have and should have been avoided. I had spoken to my sister-in-law several times. You've got to make a plan. You've got to make a plan. And like many other parents, she just kept putting it off. Let's dig in now to the details and give you some points where you can start. I believe as a financial planner, who works with families with special needs children that there are 3 phases. First and foremost, you have to take care of your own financial situation and your own retirement security. That's step one. How can you decide how much is available for you to set aside for your child's future support and care if you don't know if you're on track and you have enough or you have excess that you can set aside? The second phase is obviously you need to prepare and plan for your child's current and future support and care. The last phase is like anything in life, there will be curveballs along the way. Curveballs that you may survive, curveballs, unfortunately, like my sister-in-law, you will not survive. And you have to face the reality and take care of that. Let's dig into the first phase. You're going to create your own financial plan, so to speak. First of all, take stock of everything you have. Gather all of your documents, the retirement documents, your pensions, your 401ks, 403bs, your IRAs, a list of any employee benefits. Then take stock of your own personal savings, investments, any inheritances you might expect to receive. Take a look at your life insurance. Life insurance is critical because quite often parents or individuals will purchase life insurance and then they never look at it again until they get a letter from the insurance company going, guess what? Your premium is no longer able to carry this policy and you have to pay a tremendously huge increase in premium or the policy will lapse. You need to look at this. Most importantly, when you're gathering all these documents, is that you need to review the beneficiary designations, the primary and the secondary or contingent, and make sure they are current and up to date. My suggestion is that you contact all of the appropriate officials, the annuity and insurance companies, your pension administrator, 401k, IRA administrators in writing by letter, and I'll explain why in a minute, and ask them to send you and reply in writing by mail with a complete listing of all primary and contingent beneficiaries on your appropriate document, your IRA, your 401k, or your life insurance. And here's the reason why. I recommend you do it in writing by mail. Several years ago, there was a very famous story called The Pension Pickle, and it happened in New York. A young woman started teaching in the city of New York, and she worked as a teacher for about 10 years, and then she got married. And every year, her family, she and her husband would get a computer printout, you may have had one yourself, of all the benefits that she was eligible for. And it said that her beneficiary was her estate. So she and her husband never changed the beneficiary because he said, I'm your husband, it'll all come to me. She died, and the computer printout was wrong. When she started teaching, she had written on her beneficiary form that it was her sister who would get all of the money. And her husband took it all the way to the New York State Supreme Court and lost $1 million in pension. So that's why I say, don't just accept some computer printout or a just, pro forma email. Have them double check and reply to you by regular mail. So you've gathered all your documents now and you've determined if you've sent away the letters to get all the beneficiary designations. You've checked your employee benefits to see if you've got any kind of life insurance or anything else. What's your pension benefit? Now let's build the foundation. First off, let's look at your current estate planning documents, and I hope you have current estate planning documents. Review your wills, any trusts that you have, and powers of attorney to make sure that they are up to date and designate appropriate people to act on your behalf or as your executor. And also, even though powers of attorney do not have an expiration date, financial institutions, particularly banks, have been known to not be unwilling to accept any power of attorney that's more than 5 years old. So my recommendation here is Take a look at your wills, your trusts, your powers of attorney, absolutely every 4 to 5 years. Make sure they're up to date and get new powers of attorney. You may want to consult with your attorney about your documents to see if there's any current changes in tax or estate laws. There's going to be a major change in the estate tax laws coming next year. So you've got all your estate documents in a row. Now, what's the next step? You need to determine what's your cash flow. How much income do you have coming in every month, and what are your expenses? Because this means, A, how much do you have available to potentially set aside irrevocably for your child's support, either now or in the future? And do you have enough to be on track for your own retirement? You will be no good to your child if you are scrambling to support yourself, or you didn't set aside enough. When you do this, you will want to look at your retirement and what is your Social Security projected income and your savings, and determine if you are on track for your own retirement. Next, as I said, there are curveballs in everybody's life. The curveballs are: somebody gets injured and can't work until they're ready to retire, and there's a significant shortfall or lack of income. Or a primary or one of the family wage earners doesn't make it to retirement and unfortunately dies, and the family is left with a mortgage and without enough income coming in to pay the monthly expenses. After retirement, one of the biggest risks is long-term care. Think about this. You may have saved a lot of money that you intend to leave behind to help support your child with a disability, and instead, you go into a long-term care or assisted living facility, and without a proper insurance or provision to pay for that, you will be depleting your nest egg and leave nothing. There are current types of programs that add a long-term care benefit onto life insurance or onto an annuity. So, but it's critical to look for them to make sure you've covered all your potential curveballs. Part of your planning is to think about your Social Security claiming strategy. If you have one spouse that's a bigger wage earner, and another spouse who doesn't perhaps make enough, maybe a lot of times it's the wife who stayed home and took care of that child for a long time, you need to decide when and how you're going to claim that Social Security. The critical piece here is there is something called the family max. When you have a child with a disability and one parent starts to claim their Social Security retirement benefit, the spouse who wants to claim half of that as a spousal benefit will be very, very surprised, because the family max will come into play, which can significantly reduce the spousal benefit, and in some cases also reduce the benefit that your child was receiving from Social Security. It's complicated. You need to be aware of it and start planning for it. And I've done this for some people, so if you need some help, let me know on this one. We've covered your situation. Now you know what you have available, if anything, to set aside for your child's support and care. Now let's look at the second phase of planning, which is you need to plan for your child's current and future support and care. You see here that my motto is your next crisis is not on your calendar, and this is your goal to take action. First step, and many of you may have a child that's way past the age of 18, but some of you may still have a child that's in high school and coming up on the age of 18. If you are aware, you know that when a child turns 18, a child with a disability, they are eligible to apply for government benefits without including the parent's income and assets. Most people, if they include the parent's income and assets, are not able to qualify for government benefits when their child is under the age of 18. So you are ready to apply for government benefits, and you should apply, regardless of whether you think you can afford the support that you need for the rest of your child's life. now's the time to apply for it. It's there for you. You should start collecting it. There are two kinds of government benefits a child is a disabled or a child with a disability is eligible for at the age of 18. The first is SSI. It means supplemental security income, and it's typically for people, individuals who don't have any work record. Along with that, your child will be eligible for Medicaid. And if you know anything about these types of programs, you can't have a lot of money or income in your own name. That's the restrictions, and we'll talk about that later. Let me segue here a little bit and talk about Medicaid and healthcare. If you are working for an employer, a corporation, whatever, where they have, or even a union, perhaps, where there is a company health insurance program. Under Obamacare, it said that your company group health plan must cover a child until they are the age of 26, with the exception that if your child has a recorded disability, recorded with Social Security, that company group health plan must continue to include that child in the group health plan past the age of 26 for as long as you work for that company or you retire. There are a couple of exceptions where they don't have to cover that child, but typically the company health insurance will be the primary insurance and Medicaid will be the supplement. So you want to double check with your company. And by the way, I did have a client whose son was turning 26, and the HR department told the mother who carried their son on the health plan that he was going to have to go off the benefits. They wasn't going to be covered by the group health plan anymore, and they were, to be blunt, freaking out. I talked to them and I said, no, call the health insurance company. In this case, it was Blue Cross Blue Shield, and talk to the benefits administrator for your company's group health insurance. And it turns out I was right, and they were able to go back to the HR department and say, no, this is what you have to do. And they were able to continue their child on the group health insurance, which obviously is a lot more beneficial than just plain Medicaid. At some point down the road, your child may be eligible for a better quality of government benefits, SSDI, Social Security Disability Insurance, and also Medicare. Here's some definitions that I've provided for you to explain in more detail what SSI and Medicaid is. One of the things you need to know is that if your child is receiving government benefits such as SSI, they can only have $2,000 total in assets in their name. Now, if you already have assets in their name and you don't know what to do, we can talk about that. And there is also an exception to this $2,000 limitation. Then there's Social Security DI, SSDI, for disability insurance for someone who has a work record, or if you have a disabled adult child referred to as a DAC by the government, your child may be eligible to step up to SSDI and Medicare later in life, around the time when you are getting ready to apply for Social Security retirement, or if a parent becomes disabled themselves or is deceased. Lost my little cursor here for a second. Now we've covered government benefits. The next step is for you to research and create relevant and appropriate trusts and accounts that will shelter assets from government benefit exception and supplement what government benefits can provide for additional resources and prevent you from being kicked off of government benefits, preserve it. There are three different kinds of resources or accounts. One of them you may not need at all, but let's start with the easiest and simplest one first. It's called the ABLE account. ABLE was created in 2014 to be a resource or account where your child owns the account, and it stands for Achieve a Better Living Experience. My cursor keeps disappearing here. Here's some more details on the ABLE account, and you can refer to them in more detail. This is the one account that can be in your child's name and social security number, and it doesn't compromise their eligibility to continue or begin to receive that SSI and Medicaid benefit. You can only have one ABLE account for your child. You can't put one here and one here. Typically, you go to your local bank and get an Illinois ABLE account. The maximum amount that can go into the ABLE account every single year from all resources is $18,000. That's the current level for this year. The maximum limit of dollars you can have in that account is $100,000. If you're getting close to $100,000 and then that account earns interest and you go over $100,000, your benefits will be suspended until you bring it down. The ABLE account is actually a type of college plan. The College Financial Savings Plan, which is known as 529A, is one thing. The ABLE account is 529B. And the reason I bring this up is because when you use the resources in the ABLE account, even while you're still alive, to help provide for some additional qualified disability expenses for your child, withdrawals are free from income tax. Excuse me 1 second. Here's the next two kinds of accounts or resources that may be appropriate for you for your child. For these two, you need to speak to an attorney who is competent and experienced in the special needs arena. There is actually an organization called Special Needs Alliance. I think it's specialneedsalliance.org that lists attorneys all over the country that are members of this group. Be careful though, because some attorneys that are in the Special Needs Alliance only deal with senior citizens who are trying to be able to handle going into a nursing home. So you have to read their bio. But make sure the attorney you work with has lots of experience in this area. The first type of account after the ABLE account that you will want to consider is called a third-party special needs trust. I tell my clients special needs trust begins with an S. So that means it's the assets in this account are someone else's money. The parents, the aunts and uncles, Grandpa Joe, siblings, whatever. Okay, this is someone else's money, and you can have as much money in the special needs trust, and you can spend this for your child's benefit without the government, Medicaid, looking over your shoulder. Now, let's be blunt. You can't take the assets out of the special needs trust and have the parents buy a portion, do a round the world cruise, and not take your child with you and think that that's an okay expense. You know that this is meant to be there for your child while you are alive, if you're funding it while you're alive, and definitely after you are gone. I will tell you right now that in my experience, it is a very rare parent who can afford to save for their own retirement and then additionally save the huge amount of money that they will need to leave behind for their child. So most of the time, the most cost-efficient way to fund a special needs trust, unless you have a very wealthy relative who's going to leave a humongous inheritance for you, is with some form of life insurance. It's very cost-effective. So that's your third-party special needs trust. The other kind, which you may or may not need, is referred to as an OBRA 93 trust, which we refer to as an OOPS trust. And what this means is, oops, I have money in my child's name and they can't qualify for benefits as long as the money is in their name. Let me give you an actual case example from my very first client who had a child with a disability back in the early 90s. This was my first client, and he was badly injured at the age of 14. And there was a huge court award. And by the time I met them, they had over $300,000 left. And they were going to be having to spend down the entire $300,000 before they could qualify for government benefits, which they definitely needed. Well, that's not very fair, is it? All of a sudden, you have to spend this all down and now there's nothing left to help supplement the government benefits for your child support. That's what the court award was for. Along comes Ober 93, which I will tell you stands for the Omnibus and Reconciliation Act of 1993. It was a tax act, and they slipped in this little clause, and here's the way it works. You set up an Ober 93 trust. Let's take my client. They had over $300,000 left out of their court award. You set up the Ober 93 payback trust. I'll explain how that works in a second. And you can legally transfer those assets that are in your child's social security number. Think about grandma giving them an inheritance of stock when they were born, or maybe you started a college savings plan or a Uniform Gift to Minors Act before you realized your child was going to have a lifelong disability. Transfer the money, the assets, legally into this Ober 93 payback trust. Your child is now eligible to qualify for government benefits. Here's the way this payback trust works. It is intended that at some point when your child dies, Medicaid will come to you and say, we need to get paid back for all the benefits we provided during your child's lifetime, and we're going to look to this Ober 93 trust. It is a non-recourse trust, which means, let's say we put $300,000 in, and by the time my client died, there was $250,000 left. Medicaid comes in and they say, oh, we paid out $200,000 in benefits. We'll take the $200,000 that we paid out. Thank you very much. And the remaining money goes to another family beneficiary. Let's look at the reverse. You have $250,000 left, and Medicaid comes in and says, we paid out $400,000 during your child's lifetime, and we need to get paid back. They will take the entire balance, but they will not look to any other account or resource. It's a non-recourse payback trust. Because Medicaid is allowing you to set aside this money and immediately qualify for government benefits, they are very, very restrictive on what you can use this money for. So you need to be very careful on what you do with the money that's in an Ober 93 or OOPS trust. The way I tell my clients to remember the Ober 93 or OOPS trust, it begins with the letter O. It is money that was originally owned by the individual with the disability. So we've covered ABLE accounts, which are very low cost and very easy to set up at your bank. We've also covered third-party special needs trusts, and if necessary, an Ober 93 OOPS trust. The last two are formal trusts that you will need the advice of a competent attorney to establish. In many instances, the parent's resources may not be sufficient to justify the expense from an attorney of establishing the trust and filing tax returns and administering it. So you may want to have a discussion with a knowledgeable person, maybe about whether or not you want a standalone trust, as we've just discussed, which is for you alone, or whether you want to consider a pooled trust. A pooled trust means instead of you having your own special needs trust, you go to a charity that's usually affiliated with some form of disability or general disability charity, and they have a special needs trust that you can deposit the money into your child's account, and then the charity will administer the investing of those assets, the filing of the tax returns every single year, and also the distribution for your child's supplemental needs. The one caveat is when your child dies, whatever may be left in their account in the pooled trust goes to that charity. But it's something to consider. The cost for you to support your child during your lifetime and while what is their life expectancy, I find for most parents is much larger than you realize. Autism Speaks, which many of you may be familiar with, which is an autism advocacy organization, estimates that the cost to raise a child with autism or an intellectual disability is somewhere north of $1 to $2 million. Think for a moment. You're trying to save for your own retirement, cover all your possible curveballs that could happen to you, and now you're supposed to be able to provide a resource of 1 to 2 million. This is where the reality check comes in, and it's not easy. So, but you have to take the time, and you can do that with some advice and help. If you want to give me a call, I can help you. Let's determine what is your child's actual potential living expenses. Here's another thing. If your child is going to live, for example, in a group home, as happened with my nephew Stephen when his mother was killed, and the SSI that and the SS or the SSDI that your child may be receiving when the parent dies and your child goes into, say, a group home, the bulk of that income will go directly to that group home. And they will leave very little money, typically barely $50 for your child to supplement their own resources. My nephew Stephen, he's got to have his own TV and watch that TV in his room. How are you going to afford that so you can't include that income from SSI or SSDI as a resource if your plan for care involves your child moving into some form of institution such as a group home. Let's look at that. Now we've determined what you project will be the monthly expenses. What kind of inheritance or family gifts might you expect? How much do you realistically think might be left at your life expectancy that you could leave in a special needs trust? And any shortfall in providing adequate resources should be provided through some form of life insurance. If you already have existing life insurance and we do an audit to say it's still valid and it's going to last for your life expectancy, you may be able to simply change the beneficiaries. One thing I did for a client of mine was that her husband was chronically ill and she took out a new life insurance policy. But in this case, what we did was we named her husband as the primary beneficiary because there are curveballs. She could have been killed in an accident and died before her husband's shorter life expectancy. Her husband was the primary beneficiary, and the special needs trust was the contingent, so that if she did die before her husband, he could evaluate their assets and say, give me part of all this life insurance, or I don't need any of it, and then it would go into the special needs trust. I've already told you what happened in my family. And that experience, which honestly was horrific, I watched Stephen have several autistic meltdowns during that week. And that's when I created a third phase for planning. And I call this the Special Needs Crisis Checklist. Remember I told you that first responders were knocking on the neighbors' doors? They had no information of what was going on. My other thought at the time was, what if Stephen had been in the car with my sister-in-law and he survived? What if they didn't know if he was in shock or that he is nonverbal or he speaks Korean or he's deaf? That's when I created the Special Needs Crisis Checklist. That here's the website you can go to and request a blank PDF fillable. I ask you to email me so that I can send you the PDF form and you can type in all the information. It contains who to call for you in a case of an emergency, sort of your family tree. Who is your primary care physician that needs to be called? It tells first responders that you have a child with a disability. One of my clients has a child that lives at home with them who is completely physically dependent, needs in a wheelchair, on oxygen, needs to be fed and bathed and dressed. If that person gets into an accident and ends up in the hospital or worse, how will first responders know that you have to call somebody to get to the house to care for that child? So you notify first responders that you have a child with a disability. What's the child's name? What's their diagnosis? Is it autism? Is it Down syndrome? Is it cerebral palsy or PDD, pervasive disability disorder? Whatever it is, you tell them. Then you also, in my opinion, should list any collateral diagnosis. What if your child also has a seizure disorder or is insulin dependent diabetic? Your child may be past due for their medication. First responders need to know this kind of thing. Also, how to communicate with your child. Do they speak Korean? Can you speak to them directly? Are they hard of hearing? If, like Stephen, they're nonverbal, do they have an assistive device? Or here's a list of people that the first responders can call that can be coming to your aid to speak to the first responders or interpret on behalf of your child, regardless of how they communicate. And then it also could be the same people who are the respite caregivers who could be there to help support that person in an emergency. And lastly, who is your child's physician? Where do you put it? Please don't just put it in your phone. Your phone could get lost in a crisis, and now it's gone. You can put it in your phone, put it in the console or glove compartment of your vehicles, all of them. Keep at least one at home. Give one to one or two family members so they know that this exists. And you may even want to take this to your local fire department and say, I have this. Here's this information you should know about. Again, I'm more than happy to provide this special needs crisis checklist to you at no charge. It came out of the crisis that my family suffered and didn't need to do. I know these are tough things, and I hope that you can begin to take action. I have one more thing to share with you, and that is this. This picture on this slide doesn't do very well. There we go. Let me do it this way. I have received several copies of this book, and it's called the In Case of Emergency Guidebook. Whether a person survives a crisis or whether they don't survive, this is the information that your family needs. It has in here, for example, who's your doctor? Who's your attorney? Who's your financial advisor? Where is your will? I will share a couple of personal stories with you that I am now talking to all of my clients about the things that are in this book. My brother died a couple of years ago, and I was fortunate to be with him in Florida the entire last week of his life. And he was very mentally competent, and we had some very honest discussions. He knew he was near the end. I'm a financial planner, and I'm here to tell you that I forgot to ask him where he kept his will. I asked him where to keep his ashes when he was cremated. I asked him which funeral home to talk to. I forgot to ask him where he kept the will. And believe me, I'm scrambling around in his house in the middle of my grief to try and find the original of his will. I lived through something that I should have had this book. The other thing, and this is a true story, 8 years ago, my cousin, who had retired from a very powerful job and his wife had been a homemaker and mother, he crashed his plane up in Door County due to wind shear. Several months later, his wife was up at 3 o'clock in the morning when a neighbor called because she said, I can't find the passwords to get into the computer. It's in here. Everything. Who to call in case of an emergency. So, as you can see, this booklet is, I'm trying to get this straight for the picture. Here we go. Okay. It needs to be mailed. If you would like a complimentary copy, I'm more than happy to mail it to you. Here's my email address at the bottom, vjvillers@sigmarep.com, and I'll send it to you. You've got the special needs crisis checklist email me at that special address, and I will automatically send you a PDF fillable copy. If you know anybody else who would like either one of these documents, or preferably both, I'm happy to provide them. It's my mission, because of what happened in my family, to get you to take action. One of my mantras is, your next crisis is not on the calendar. And just so you understand clearly what that means, no one who died on 9/11 had it scheduled. It doesn't matter what age you are. It could happen tomorrow. And no matter how overwhelmed you are, I hope that I have provided you some steps to take so that you can begin to take action. Excuse me one second. What I do with my clients, and then I'll close. Sorry. I tell people to set deadlines for holidays. For example, Memorial Day is coming up, and then there's the 4th of July, and there's Labor Day. Because I think it's easier to remember a deadline that's associated with a holiday rather than a specific day on the calendar. And oh, by the way, nobody wants to tie it to tax day, April 15th. That's not a fun thing to do. So set yourself a deadline. Tell yourself that by Memorial Day, you will have at least pulled together all of your documents and reviewed them and sent away the letters to ask for the primary and contingent beneficiaries. And you will start to look at all the assets. And if you don't already have those accounts set up that can be available to hold and preserve the assets to supplement your child's government benefits, that you will at least start researching them. So, as always, if you have any questions or you'd like to have a more deep personal discussion, I'm available either by phone, in person, or on Zoom. And I think that's about it. And Linda, it looks like we're just right at about 45 minutes.
Yep, that's exactly what you said. All right, we do have a couple questions in the chat, and if anyone else has others, please share them in there. The first one is, can you share how much money you've seen targeted for a special needs trust? Maybe the range from a low amount to a high amount.
Thank you. That's an excellent question. First of all, there's what I would call the ideal situation. We've already seen that the autism advocacy group says it can be anywhere from 1 to 2 million. It's not always feasible, but you have to do something. I've seen a low of about 2 to 300 to well over 1 million to close to 2 million. Now, that means it's a combination of things. And quite frequently, it includes a life insurance policy. People don't like to talk about life insurance. It's not fun. It's not jazzy. But the reality is that when you pay a premium for life insurance, you are immediately covered for the full amount, and you will never be able, the premiums never equal the amount of life insurance benefit. I've seen, you have to figure out what you need for your own self, and then what you can realistically afford, either in a life insurance policy or what you're going to leave behind, or what you can save into an ABLE account or a special needs trust during your lifetime. Start with the number of what you really need, and you have to bite the bullet and do that calculation, and then realistically say, but yes, what can I really afford? Sometimes you start with naming your child as a contingent or partial contingent beneficiary of your existing IRAs and 401ks, and then you take a look at your existing life insurance and see if you can maybe change the beneficiary from a spouse to the special needs trust. Remember, if your life insurance is a large amount, you can't leave it to the ABLE account because it'll go most likely over $100,000. Hope that answered the question.
Okay, the next question is, for still a group home, should parents budget donations to the group home as part of money needed after their death?
My gut feeling, and I'm not, is probably not, because here's the point, okay? If you can afford to make the donation to a group home, a SILA, whatever, on top of all your other planning resources and requirements, then go ahead and do it. But not do it if it means that you aren't able to adequately fund the resources for your child. And you definitely want to start looking into those living arrangements for when you are no longer to have your child living in your home, excuse me, or when you are no longer alive. When my sister-in-law was killed, no matter how many times I talked to her, she had never made any plans. Okay. And she was already retired when this happened. And it was an absolute piece of luck that Stephen was in this daycare program out near where they lived, about 2 hours west of Chicago. And the people that ran the daycare program also had group homes, and they were fortunate that they had an opening where Stephen could start living in the group home. And the blessing for him with autism was that the resident associates, if you will, who lived in the group home were the same people that were affiliated with the daycare program. But you've got to start finding these kinds of resources if you think you're getting close to that. Now, I will tell you that I have a cousin that has a daughter with very, very severe Down syndrome. And they knew this shortly after she was born. Shortly after she was born, they connected up with Misericordia. That was their choice. And they started becoming heavily involved with Misericordia, so that when my cousin's daughter reached late teens, early 20s, and there was no one at home during the day because her younger brother was off to college and both parents worked, then she transitioned and she now lives permanently at Misericordia. But you can't wake up at age 20 when your child is 20 and go to a facility that has limited openings like Misericordia and say, oh, can my child come in now? The answer is going to be no. Every situation is different. You try to calculate start with what you really, really need for yourself for your retirement, and what you really, really need for your child. And then when you've determined what you really, really need for your child under the ideal best of quality circumstances, realistically determine what your resources can allow you to do without compromising your own retirement. I will say again, in my mind, it's very critical that you try to get some kind of hybrid long-term care coverage for yourself. At least 1 in 4 people will end up in a nursing care facility, assisted living, or long-term care. I have several clients I'm working with right now that are moving into a retirement home that will convert to assisted living or full-blown facility care. The full-blown facility care in this area is over $100,000 a year. It's much easier to try and find some kind of a hybrid solution as a rider on your own life insurance, and then not deplete the resources you had earmarked for your child. I know these are tough topics. This is what I do. You've got to deal with the tough issues and not keep pushing it down the road because it's an overwhelming situation. Start somewhere.
The next question is, can you explain more about the Social Security Family Max?
Ah, yes, but it's really, really complicated. Ah, okay. I'm going to make this as simplistic as I possibly can. Okay. The calculation to determine the dollar amount of the family max is really, really tricky. And since I don't have a slide to discuss it, I'll try and make this rather simplistic. let's assume for the sake, excuse me, of discussion that you're projected, let's say the mother stayed home to take care of that child with a disability. So you have one major wage earner, and maybe the mother has some Social Security credit. She's worked for a while before they got married, or worked part-time or whatever. Okay. But it's obvious that she is going to be claiming a spousal benefit on her husband's Social Security. If you're familiar with traditional Social Security retirement, let me go back to my example. Let's say dad is going to be collecting at full retirement age, which these days is typically around age 66 or 67. That's when you get your full benefit without a permanent reduction. So you're at 66 or 67, and let's say dad is going to get projected $2,500 a month. Well, mom thinks if she claims a spousal benefit, she's going to get $1,250 a month. But because their son, Joey, let's call him, is eligible also to receive a benefit under the father's Social Security record, mom will not get $1,250. The total family max, which is somewhat slightly larger than the father's total benefit, the father will get his full benefit. And then the remaining portion that is left for a third family member, such as a child and the spouse, will be split equally. And mom may have thought she was going to get $1,250, and all of a sudden her first check is $852. So it's very complicated. It's very tricky. And you have to be fully aware so that when you go to claim, you may say, wait a minute, or maybe you let dad claim his Social Security, and maybe mom can just claim hers and let the child, Joey, claim on the bigger wage earner Social Security benefit. And Linda is shaking her head. Yes. Have you been down this road?
Yeah, I mean, if you look at your Social Security statement, they'll tell you what your benefits are. If you start claiming Social Security at your full retirement age or whatever, it'll show what the family max is, because we've been looking at in our family. And what you just said, Vivian, is exactly our case. It's better for me to take it on my own earnings, even though it's much less than my husband's, but half of his is about the same as mine, and that leaves more for our son.
Right, exactly. And it's very, very tricky. And all too often, people go to claim and they don't realize until they get the first check and they go, wait a minute, this was not the income I was planning to live on retirement. So I hope that clarifies the family max. And Linda, as you've just explained, it can be very confusing and complicated. So you're muted, Linda.
Premature muting, sorry. One more question in the chat so far. It says, do you have any advice on choosing a trustee for a special needs trust? For example, a family member versus a financial planning or law firm, what kind of burden is it?
Oh, very, very good question. Okay. First, okay, typically the parents, one or both of the parents, will be the trustee when you establish those types of accounts. Now, what happens when the parents are gone? I will tell you that quite frequently the knee-jerk reaction is to name a sibling. So let's take Joey and his sister Susie, who is going to become the successor trustee. First of all, you have to be sure that Susie is willing to do this and not thinking it's a burden, because she's kind of had to take a step back, and let her brother Joey be the primary issue in the family while she was growing up. Okay. Whether you name, let's assume Susie, the sister, is willing to assume the role of trustee on the special needs trust and the over 93 trust, if appropriate. But if Joey is like my nephew Stephen and is not really all that aware, it doesn't matter. Leave Susie the trustee of the special needs trust if she's willing. Now, there was another situation when I was served on the board of the Arc of Illinois where we had an autism conference, and a father came to speak, and he was from New England, and he said his son was also there, and his son was very high functioning. Here's why he told me he didn't name the sister as the successor trustee. Here's the example. Joey's reasonably competent, and Susie is named as the successor trustee of the special needs trust. Joey comes to Susie and says, I need more money from my trust for ABC. And Susie goes, no, Joey, we can't afford any more withdrawals this year, or you don't need that, or it's too much. What have you done? You've made Joey angry at his sister. You've compromised the sibling relationship. Instead, what this gentleman did, who spoke at the autism conference for the ARC, he said, we named another relative, Uncle Bobby, for example, assuming that's a younger person also, about the same age as Joey and Susie. Uncle Bobby is now the successor trustee to the special needs trust. Joey goes to Uncle Bobby and says, I need money. And Uncle Bobby's going to turn around to Sister Susie saying, you know what's going on with Joey. Does he really need the money? And Uncle Bobby becomes the heavyweight. There is a problem that you need to double check if you name a bank as a successor trustee. First of all, a lot of banks are not knowledgeable about the kinds of distributions they can make from a special needs trust. Secondly, bank trust departments typically are intended for very, very large estates, and the fees that they charge on a trust may be prohibitive for the size of your special needs trust. Lastly, sometimes a bank will try to be ultra conservative to preserve the total dollars that were established in the special needs trust, and they will be unwilling to invade that principle to make a valid distribution. You may want to have an attorney do it, or you may be able to find a corporate trustee. There are standalone independent companies that are corporate trustees that are knowledgeable about special needs trusts. Barring all of that, you may want to reconsider a pooled trust where you have someone that will be available. And you could name, you could consider when you're setting this up, naming your sibling. Let's go back to Susie and Joey. You could name Susie in the special needs trust as a successor co-trustee or as an advisor, where I've had clients put language in a trust saying that the successor trustee must confer with this person about what is appropriate for investing the assets or making distributions. So that's a little bit more complicated, and I hope I've clarified it.
Okay, one other question came up. What companies offer a hybrid life insurance long-term care policy?
Several. Several. There are several major companies that offer this, and each company has different situations. I will be very blunt with you. There are some life insurance companies that are much more conservative and rigid, and for want of a better term, a little bit more nitpicky in their underwriting. And there are other insurance companies that are maybe a little bit more lenient and say, oh, well, if you don't have all these other health issues, but you're overweight, but your labs are good, we will consider you as a standard rating. And another company might consider you a substandard rating, which raises the premium. The idea is to find the proper company, and also what is the benefit understand that a hybrid life insurance policy means that you take out the insurance policy on one person, not joint. And if you need to draw down on that for long-term care, in essence, what you are doing is you are decreasing the death benefit. And that will cover the insured person for slightly more than 2 years. The average stay in a nursing home is 2.5 years. My mother, God rest her soul, lived 2 weeks short of 2.5 years to the day. But here's another option for you to consider. There are, if you have quite a bit of cash, there are options out there where you can do one huge lump sum and then get a one-time only premium and then never have to pay premium again to get that rider. There are also annuity companies. There are a few I've just been working with recently where you put a deposit into a traditional annuity, and immediately, depending on your age, the amount that you can draw down for long-term care is double or triple what you put in. So for example, a $150,000 annuity investment, and maybe you already have an annuity in existence, can give you $450,000 of ultimate long-term care benefit. One other thing I wanted to say real quickly, since we're talking in detail about the insurance issues, I referenced the woman and the husband that he had a chronic illness. Typically, when parents are considering buying life insurance to fund the special needs trust or to add to the other resources of the special needs trust, many times they will look at something called a second to die policy. Second to die will insure both parents in this example and will only pay when the second person dies. The advantage of this is that one of the two people who is insured can be uninsurable. In this case, the father had a chronic long-term disease that would have made him uninsurable. So the knee-jerk reaction would be, oh, let's just go buy a second to die policy. And we crunch the numbers. I'm all about the numbers and crunching the numbers to figure out what you need and what you can do. We crunched the numbers. In this case, they needed about $350,000 of additional life insurance. And then, as I explained earlier, what happened was I said, wait a minute, the father is most likely to die first because of his illness, but what happens if mom dies first because of a tragedy? So we crunched the numbers for the same amount of insurance, $350,000 on the mom alone. Guess what? The premium was less. So what we did in this situation is we bought the insurance on the mom. And in this case, we made the father the primary beneficiary just in case the mom did experience a life-ending tragedy, such as my sister-in-law did. And maybe she didn't live long enough to fund the family retirement nest egg. The father could take a look if and when the wife died prematurely, so to speak, and say, do I need this money for my retirement security to pay off bills? I can take part of it or all of it. And if I don't need part of it or all of it, there's something called, I can disclaim that life insurance death benefit, and then the insurance company looks to the secondary or contingent beneficiary. And in this case, it ended up being the special needs trust. So.
Okay, one more actually popped up. Does a person need to be a U.S. resident in order to manage a special needs trust or to be a guardian of an individual with a disability?
I don't know the question legally, but my guess is yes, and for this reason, okay? If I don't know if you're talking about someone who lives here and is not a U.S. citizen, but the question was about a U.S. resident. So I'm assuming that this person you're referring to and considering is someone who lives in a foreign country and may or may not be a U.S. citizen. really not the best idea. There's a lot of complications when someone lives in a foreign country. Remember that when you have something like a special needs trust or an OBRA 93 trust, you can't write a check payable to the individual with a disability. And I recently had a client who died in her mid-90s, and she did have one of her children who lived in a very small town in France. He did not have a single US bank account. Financial regulations for my type of investment world, we are prohibited by federal law from sending money to a foreign bank in another country or mailing a check to a foreign bank. I've also seen situations where, you know, it's just a bad idea for a person to name a family member who lives in another state to be the executor of their estate when they die. If there's no one else, that's fine. But in general, I would say, how can someone who is not a resident of the United States and lives in a foreign country be the guardian and know what's going on with your child with a disability? I think it raises a lot of issues and complications, and I don't know what the law is, but my advice would be, I think you're opening up a Pandora's box and you may live to regret it.
I think that's all the questions that I saw in the chat. Is there anybody else has anything? Otherwise, we will say thank you to Vivian for her time today and to all of you for attending. And oh, wait, one new message. Hang on.
And let me just remind people, here's my contact information. And if you want the special needs crisis checklist, go to specialneedscrisischecklist.com and request it. And here's my email and my phone number if you want to request the booklet. In case of emergency, I'm happy to provide this. I think it makes a comprehensive total package. Or feel free to reach out to me if you want to have an individual consultation or you want some help with some financial planning matters. Sorry, Linda, go ahead.
No, that's okay. Everybody should have gotten a copy of the PowerPoint in the email that CTC sent out Wednesday evening. So you do have all this information. If for any reason you didn't receive it, just send us an email and I can forward it to you. Thank you again, Vivian. It was fabulous. I'm sure I'll have some follow-up questions for you.
I'm happy to help wherever I can. The
Great.
important thing is, I hope that what I've discussed here has really made you realize as a parent that if you haven't done so yet, you need to start taking action. And we all get overwhelmed with life's daily, things that you have to do and pushing things down the road that you have to do. So hopefully this will get you to set a deadline of an upcoming holiday and tell yourself you're going to start taking action now and have it at least in the works by the next holiday. Thanks.
Thanks so much, everyone. Have a wonderful weekend.
Thank you, everybody.